Say the wrong thing to a cop about your firearm, and you could lose everything, your permit, your savings, even your freedom, before you realize what happened. I've spent years analyzing traffic stop footage and police testimony, and I've identified 5 specific statements gun owners make that prosecutors love to hear. These aren't opinions. These are the exact words that turn lawful carriers into convicted defendants. Before we go further, understand this. Last summer in Arizona, a permit holder uttered 4 words during a highway stop. Those 4 words resulted in license suspension, $12,000 in legal costs, and nearly 2 years fighting charges. He genuinely believed he was being transparent. He couldn't have been more mistaken. Let me show you what to avoid and what to say instead. Statement 1. I had no idea. Picture yourself carrying concealed. Then an officer informs you that you've entered a prohibited location. Maybe it's a federal building entrance, a campus parking structure, or a municipal office. Your instinct screams to offer an explanation. The phrase that tumbles out, I had no idea this was restricted. Here's why that destroys your defense. The legal doctrine called ignorantia juris holds that not knowing the law provides no protection. When you announce, I had no idea, you're actually admitting you committed the prohibited act. You carried where you shouldn't. The only question remaining is whether you intended to break the law, and you've just eliminated your attorney's ability to argue around that element. Consider what happened in 2023. A Mississippi carrier was discovered armed inside a county courthouse parking area. He immediately told the deputy, I had no idea weapons weren't allowed here. The prosecutor played that recording at trial. Ignorance confessed is guilt confirmed. The outcome? Misdemeanor conviction, $1,800 penalty, and a 3-year ban from carrying concealed. His defense lawyer later stated the charges might have been dismissed entirely if his client had simply refused to answer questions. What should you do instead? When confronted with an alleged violation, provide 0 information about your knowledge or lack thereof. Your only statement, I need to speak with my attorney before answering. Full stop. Let your lawyer address awareness and intent after examining the actual statute and building a legitimate defense strategy. But there's another phrase that sounds even more reasonable. Statement 2, it's just in my truck. You're pulled over for an equipment violation, maybe a broken headlight. The officer asks if there are weapons in the vehicle. Wanting to appear helpful, you respond with something like, yeah, it's just in my truck, or it's just in the center console. That innocent word, just, becomes a legal confession of possession and immediate control. In court, prosecutors will argue you deliberately positioned that firearm exactly where you described it. If that location violates any ordinance, perhaps you're parked near school property. Perhaps you've crossed into a jurisdiction with stricter storage requirements. Perhaps your permit doesn't authorize vehicle carry. You've given them every component they need for a conviction. Real example from Florida, 2022. A motorist informed a state trooper his pistol was just under the driver's seat. The trooper retrieved it and discovered it was loaded without being secured in a locked case. Under Florida Statute 790.025, that configuration is prohibited without proper licensing in specific situations. This driver possessed a permit, but it had expired 14 days earlier. His own description of placement and accessibility was used to demonstrate he maintained instant access to the weapon, escalating the charge to carrying concealed without authorization, a third-degree felony with up to 5 years imprisonment. The correct approach? If your state mandates notification, you simply state, I'm notifying you that I'm a licensed carrier. Nothing more. They'll inevitably ask where the firearm is located. You respond, I'd prefer to address that with my attorney present. Does that feel uncooperative? Perhaps. But roadside cooperation doesn't mean volunteering information that becomes ammunition against you later. Silence protects what words cannot defend, which leads to the third statement, the one responsible for more arrests than you'd imagine. Statement 3. I have a permit. Wait, isn't declaring your permit status exactly what you're supposed to do? Not quite. The problem isn't announcing you're permitted. The problem is what typically comes next. Imagine this scenario. You announce I have a permit, and the officer requests to see it. You reach for your wallet, only to discover your permit lapsed last month and you forgot to complete renewal. Or maybe you moved recently and didn't realize your previous permit isn't recognized in your current location. Or you're in a jurisdiction that doesn't honor your specific permit classification. Now you've delivered a false statement to law enforcement. That's a separate criminal offense in 43 states. In Virginia, it's classified as a Class 1 misdemeanor carrying up to 12 months incarceration and a $2,500 fine, completely independent of any weapons charges. Tennessee, 2024. A permit holder told an officer during a stop, "I have a permit for this." The officer checked the system and found the permit had been suspended due to an outstanding traffic citation from half a year earlier. The driver was completely unaware of the suspension. The district attorney charged him with both unlawful carry and providing false information to police. Total damage: $8,000 in attorney fees, 40 hours community service, and a permanent mark on every background check he'll ever face. Better wording: I'm a licensed carrier, and I'd like to verify my current permit status through counsel before proceeding. If your documentation is valid, your attorney confirms it immediately and you're clear. If there's any issue, an administrative error, a delayed renewal, a reciprocity problem, your lawyer resolves it before you've spoken a single word the state can quote against you. Now, the fourth statement sounds like you're standing up for yourself, but it actually hands prosecutors proof of criminal intent. Statement 4. It's for protection. An officer asks why you're carrying. You want to seem reasonable, responsible, law-abiding, so you explain, "It's for protection," or "I carry for personal defense," or "You never know what could happen out here." Congratulations. You've just established motive and deliberate intent. If your carry situation is later determined illegal, wrong location, wrong documentation, wrong state, the prosecutor now possesses your own testimony proving you intended that weapon to be immediately available for potential use. That elevates the severity of charges in many jurisdictions. California enforces some of America's most restrictive gun laws. In 2023, a concealed carry permit holder was found armed within a clearly posted weapons-free zone. When questioned about why he was carrying, he answered, "For protection, there's been criminal activity in this area lately." The prosecutor weaponized that statement, arguing he knowingly disregarded the posted restrictions because he prioritized personal security over legal compliance. What should have been a misdemeanor became a charge of willfully violating firearm restrictions. He spent $12,000 and 18 months in court. Here's how judges interpret this. When you state you're carrying for protection, and they subsequently find you in violation, you've admitted you knew the gun was on your person, and you intended to use it if circumstances demanded. Both elements, awareness and intent, are precisely what district attorneys require to pursue enhanced charges. Your response when asked why you're armed: "I wish to consult with counsel." That's the only reply that shields you. Don't justify. Don't expand. Don't feed them material. But the fifth statement, this one annihilates more defenses than all the others combined. and I guarantee you've thought about saying it. Statement 5. I wasn't going to use it. This is pure panic response. The officer discovers your weapon, and you immediately want to de-escalate the situation. So you blurt out, "I wasn't going to use it," or "I completely forgot it was even there," or "I haven't touched it at all." Congratulations! You've just admitted to unlawful possession while simultaneously destroying your Fourth Amendment protection. When you say, "I wasn't going to use it," you're confirming you knew the firearm was present. That eliminates any argument that the weapon was planted, that you were unaware of its presence in your vehicle, or that someone else placed it there without your knowledge. You've locked yourself into possession. When you claim, "I forgot it was there," you're conceding negligence. In states with mandatory secure storage laws, or in cases involving prohibited persons, negligence can constitute a distinct criminal charge. You've gifted the prosecutor a second violation. When you insist, "I haven't touched it," you're inviting forensic examination. If your fingerprints are on that firearm, and they absolutely will be if you own it, you've now made a provably false statement. That's yet another charge. Georgia, 2023. A driver was stopped with a pistol visible on the back seat. When the trooper approached, the owner quickly said, "I'm not going to use it. I forgot it was back there after going to the shooting range." The trooper cited him for improper storage and transportation. The district attorney used his own words to prove he knew the gun was in the vehicle, yet failed to secure it properly. Under Georgia code, that should have been a $100 citation. His statement elevated it to a misdemeanor with a $1,000 penalty and mandatory safety training. The proper response if an officer finds your firearm? Absolute silence. Say nothing whatsoever. If the officer questions you about it, your statement is, "I'm invoking my right to remain silent, and I'm requesting counsel." Does that sound harsh? Maybe, but here's what you must understand. Anything you volunteer in that moment serves two purposes: officer safety and prosecution preparation. Nothing you say will improve the situation. It can only make things worse. Let's review the 5 statements that can demolish your legal defense when police question you about your firearm. 1. "I had no idea" admits guilt outright and eliminates any defense based on lack of knowledge. 2. "It's just in my truck" proves possession and control at a specific location. 3. "I have a permit" exposes you to false statement charges if any detail is incorrect. 4. "It's for protection" establishes the intent prosecutors need to enhance charges. 5. "I wasn't going to use it" confirms awareness and destroys Fourth Amendment arguments. Any one of these phrases could cost you thousands in legal fees, your carry permit, or your freedom. When police ask about your firearm, remember this. Your one safe response is, "I'm invoking my right to remain silent, and I'm requesting counsel." If you found this valuable, hit that like button and subscribe to Firearm Legal Briefing. We're building a community that understands their rights. Your support means everything to us and helps us create more content like this